Well, the court took on all kinds of problems last year, and some of them are somewhat controversial, and the court jumped right in on those issues, and so we're going to do the same. Professor Hunt, yes, if you could, the first case I think that probably maybe got more notoriety than any case out of last year's term, and that is the case of McDonald versus the City of Chicago. Could you tell us what that was about and what the issues were and what the court's holding was in that?
Certainly. This was a very controversial case, and it was followed by a lot of people. There was a 5-4 decision authored by Judge Alito, and the essence of this case was dealing with the Heller case, the District of Columbia versus Heller, which was decided 2 years ago, in which the court struck down a ban, an absolute ban in the District of Columbia on handguns, and ruled that the Second Amendment right to keep and bear arms applied to the states. So we come to Chicago immediately after that decision was raised, and there are 4 residents of Chicago that then challenged the Chicago ban, which is an absolute ban on handgun ownership as well. And they also challenged the ban. The NRA brought an action against the town of Oak Park, the village of Oak Park, which had an absolute ban as well. And so the real issue here was the 14th Amendment, Section 1 of the 14th Amendment, and whether that 14th Amendment really entailed bringing the Second Amendment into the states.
Well, the Second Amendment specifically talks about the right to bear arms, but over the years the court has never addressed the issue head on as to whether there was a personal right to bear arms. Is that correct? And did they do so in this case?
Until Heller. And in Heller 2 years ago, they did address that issue and said there was an absolute right to bear arms. But when we talk about bearing arms, what we're really talking about is owning a handgun. This does not relate to long guns, rifles. And they took this on head on, and they discovered or determined that owning a handgun for self-defense purposes is a fundamental right for a system of ordered liberty. And that this is in the Second Amendment, and the 14th Amendment makes this applicable to the states. The city of Oak Park and the village of Oak Park and the city of Chicago, basically their primary defense was that the Second Amendment doesn't apply to the states, and therefore it is up to the states to apply their own laws, to experiment with their own laws as to how they're going to deal with handgun ownership.
And when you talk about the states, of course, the city and the village of Oak Park and the city of Chicago are local jurisdictions that
Yes.
had laws which were more restrictive than other jurisdictions have.
They were totally restrictive. It was an absolute ban.
You couldn't register a gun in the city of
Couldn't
Chicago.
register a handgun. Didn't have handgun ban. Had a total handgun ban. Interestingly enough, though, the idea that having a ban on handguns produces or is an adjunct to public safety is not really borne out by the numbers. Since we had a handgun ban in Chicago, in fact, the numbers of murders have gone up, not down, up by a factor of 50%. And so the 4 people who brought this case had all been victims of violence in their homes, robberies, threats, etc., and argued that the ban on handguns left them vulnerable to violence in their homes, and they needed to have a handgun to protect themselves. And the court found this was a fundamental right in order to have a handgun for self-protection, self-defense. That was the holding in Heller. That's the holding in McDonald. And now we know as a result that the Second Amendment does apply to localities and states, and it's not just about the federal government.
I mean, just so that I understand, I'm sorry, Judge Burr, did you want to ask a question?
I did. And I think what evolved from the case is whether or not states and local governments have the right to put in place a set of regulatory requirements relative to the ownership of handguns. And even in Heller and also the McDonald case, there was that discussion about, is it possible to balance the right to have and bear arms versus a local regulation that would deal with the issue of what is the risk that's at play with having individual handgun ownership, because there's always a possibility that someone in a moment of not thinking clearly could reach a handgun, commit an act that if that right wasn't present, might not have it. It doesn't discuss, though, the fact that even those who have handguns illegally are involved in illegal activity, so the rationale doesn't carry over necessarily. But there is that discussion in the case about whether or not it is possible in any level to regulate, to put in place a set of regulations that will deal with the right to have and bear arms in your own home. And I think the McDonald case suggested that an individual does have that right, but I'm not sure that it went as far as to suggest that it can't be regulated in some fashion.
That would be my question. What's
yes.
left after this case?
In fact, the court said that we can have reasonable regulations on the local and state level. Regulations like forbidding handguns to felons, convicted felons, or people who are mentally insane or have a history of mental insanity and things like that. Reasonable regulations. But you just can't have an absolute ban. And there was, as Leonard suggests, a lot of impassioned pleas that having handguns in the hands of people who were homeowners was dangerous. That they could, in a moment of panic, reach for the handgun and kill someone that they didn't mean to kill, or they could kill themselves, or strangers, or whatever. But the court said that's not the point. It's not the point whether or not this is safe. The point is whether or not people have a right to this, a constitutional right to have access. And they said, yes, they do. The state can have reasonable regulations to determine who gets one and in what time frame, like the 24-hour check, but they can't simply ban the use of handguns, the sale and registration of handguns altogether.
So did Chicago, does it come back then, and Chicago can still now try to pass, or Oak Park for that matter, try to pass new laws and see how much restriction can be put on it?
Well, Chicago and Oak Park are busy right now writing new regulations and new laws trying to comport with the McDonald decision. It's a difficult process. There's a lot of resistance, there's a lot of support on various sides, but they're trying very hard right now, both the City of Chicago and Oak Park, to write reasonable regulations that would restrict the use of handguns, but not an outright ban.
I think it's interesting to note, though, too, that the court was sharply divided on this case. It was a 5-4 decision, and those justices who dissented in the Heller case 2 years ago remained in the dissent on the McDonald case, and they continued to maintain that Heller was incorrectly decided. What often happens is if a judge is on the side of a dissenting opinion and the law becomes well established, they will often acquiesce then and say, even though I disagreed with the prior decision, that I now acquiesce and I understand that this is now the law of the land. But I don't believe that that happened in this case, because they're still adhering to their dissenting position and still maintaining Heller was incorrect.
They're still maintaining very vigorously that Heller was decided incorrectly. But remember, this is only 2 years ago. And so there hasn't been a lot of time that's passed to allow them to sort of percolate and acquiesce. It's still a very controversial subject. It was a 5-4 decision, the classic 5-4 decision split, but you have the conservatives in the majority who are saying this is a fundamental right for self-defense in the home. And a lot of the liberals on the other side, on the 4 side, say that what you really need here is to go back to the original intent, ironically enough, of what the Second Amendment was all about, and that was about an ordered militia. And the majority says, no, it wasn't about an ordered militia necessarily, even though that's no longer an issue, but it was about the right of self-defense. And that's an individual right which a state cannot ban. They can regulate it, but they can't ban it.
And I think that this also underscores a real ideological split on the court, not just on this case, but in general, because you have those conservative justices who are very supportive of the idea of originalism, that the U.S. Constitution should be interpreted as it was during the time that it was drafted. And then you have other justices, such as Justice Stevens, who just recently retired, who has a view that the Constitution is a living and breathing document that should be modified and interpreted in a more fluid way, correct?
According to modern and contemporary flows of the law.
Well, I think we could probably talk about this case probably for the whole show, but we do have, there were many other interesting cases out of the last the court term. And Judge Murray, there were a couple in the area of criminal law which visited an old case that a name we hear all the time. That is the Miranda case. I know was part of a couple of the criminal cases. What were significant cases in that area that came down in the last term of the court?
Well, I'll start by talking about Maryland versus Schatzer. And Schatzer's an interesting case because, in effect, it said it established a new bright line rule under an opinion by Justice Scalia. But let me give you a little bit of facts. Schatzer is probably one of the least appealing petitioners to any court that I can imagine. He was incarcerated for a crime, sex crime, involving a minor, and there was suspicion that he'd also committed an offense against his own son. So in 2003, Schatzer was visited while incarcerated in a Maryland prison by a police officer who was pursuing the facts related to an offense, possible offense against his son. During this interrogation, which in fact took place behind the prison walls, Schatzer, the officer began questioning Schatzer about the offense. The facts suggest that Schatzer thought that this person, this officer, was an attorney who was visiting him to discuss the case that he'd been in prison for. But somewhere during the course of this interview, he realized that this was not an attorney who was there to help him, but in fact a police officer who was investigating the allegation that I mentioned. So he terminated the interview. 30 months rolls by. His son apparently is a bit older, and the social worker assigned to him apparently was able to ferret out a few more facts related to these allegations. Schatzer is again visited in prison by a different police officer, same department but different officer, who then again took up the questioning of Schatzer behind prison walls again. During this interview, Schatzer apparently made an admission regarding the incident. It wasn't a direct admission, but enough words to suggest that he implicated himself in this offense. He ultimately was charged with the crime, tried, but pre-trial filed a motion to suppress.
And a motion to suppress is where you're saying that some constitutional right was violated, and therefore the statement or the evidence, in this case the statement, can't be used
against you at trial. And that statement would have been that he admitted the offense for which the accusations were.
And what was the court's holding then?
Well, the state court denied the motion, and in each level of appeal it was subsequently denied. He then appeals to U.S. Supreme Court, who also upheld the state court's rulings. But the issue here was that whether or not Schatzer, there was a violation of Miranda and also Edwards, in terms of whether or not there was a break in the custodial investigation that should have immunized him against any subsequent statements. And it was a 9-0 decision in the case, although Justice Stevens wrote a concurring opinion disagreeing with the bright line rule that was established by the Scalia opinion.
Well, we're going to have to take a break in a second, but maybe when we come back, if we can just get a final explanation of that, and then talk about another criminal case that came down in the last term. But this is Illinois law. This is a service of the Illinois State Bar Association, and I'm your host, John Tice. We'll be back in a moment.